his life that you would consider to be, quote, in any way illusionary, hallucinatory, or anything of that nature?
No, I did not.
How about the altar? When he talked to you about the altar, he talked to you about that on 2 occasions, didn't he?
He mentioned it in perhaps my 3rd interview. That was one of my follow-up questions, and that's one reason why I wanted to meet with him once more for wrap-up purposes, and that's why I met with him the last time, to at least get a comment from him on that. Did you ask for my interpretation of that?
I would like to know whether or not his discussion with you about what he intended to do with all of these body parts was in any way delusional.
I did not interpret it as delusional. It was certainly unusual, bizarre, of course, but sexual altars are not, let's say, it's not unheard of in major cases involving sexual crimes, but it's certainly unusual, and I think it follows his memento historical kind of interest. It would have been a source of stimulation and a further offshoot, as he called it, a further source of sexual stimulation, and certainly unusual, but not delusional or not a psychotic manifestation.
Did you ask him what he intended on receiving from creating this altar?
You're talking about the power of the...
What did he tell you? Yes, sir.
Oh, he wanted to derive power from it, yes.
Did you ask him what he meant by this altar of of objects that he was going to draw power from? What he meant by that?
Yes, I did.
And what did he tell you?
May I read his comments?
Absolutely. Tell us what date you're at.
This was discussed during my last interview, which would have been
January 9th?
January 9th.
But that isn't the first time you heard about it.
No, like I said before, it was mentioned earlier when he mentioned the black table. But something else, we were into something else, and I did not get back to the black table. And that's when he first alluded to an altar, and that the black table would have been part of that.
Let me just interrupt, if I may, Doctor, not to change your train of thought, but to ask you this. Did you start to learn that this business about the table and the altar was becoming greater than you thought it to be, that caused you to go back and talk to him one more time, or was it just something you were planning on doing anyway?
No, it was on my list of unfinished questions. In a case like this, you leave, and no matter how much time you spend on this case, even to this day, there are questions that I have since thought of that I could ask him, and pretty soon it becomes almost an interminable issue. So you just draw a line. But it was a follow-up question, and one reason why I wanted to see him again for completeness' sake.
What did you ask him about what this power was all about?
Okay, that's referring to my notes. Perhaps you know the exact page.
Probably do if I look, but you're
Well,
not.
I have it right here. Let me know.
Go ahead and read. Tell me the page. All right, let's look at page 55. When you said to him you kept some stuff, it wasn't all junk for you, he said, no, I wanted to keep the skulls and sometimes the genitals, so I didn't feel like I was losing the person completely. Was that delusional thinking?
No, I did not interpret it as delusional thinking. That refers to his still maintaining some sense of the person, memento, historical type effect, he also used these objects for sexual stimulation, but at least it was not a complete loss. A concern of his was he goes through all this and has little to show for it. One case he mentioned, all I had left was a box of bones. The skulls were a memento, just a remnant of the person that he formerly was interested in. So that was the purpose that the skulls served for him. He was not left completely empty-handed. But that was not necessarily. The skulls are related to the table on the altar in that they would have been part of the ornaments of the altar. And
Doctor, I'll let you do whatever you want to do, but so I don't lose my train of thought. Tell me what delusional is, and maybe a definition.
Yes. Delusional, it's a thought. Delusional thinking is a psychotic symptom, and as we mentioned Saturday, or maybe we didn't, psychosis is we did mention it. Psychosis is a degree of impairment that certain psychiatric disorders can have. So not every disorder has psychotic symptoms. Some do. And the common psychotic symptom is delusional thinking, where the individual develops ideas that are not based on reality.
Okay.
And they are part of an illness.
So they're part of an illness, but just before you said they are thoughts that are not based on reality.
That's true.
Now, let's talk about eating another person's body parts to want those people that you killed to become a part of you. Is that delusional thinking?
I did not interpret it that way. I can explain my interpretation if you want.
It's what, please?
I did not interpret it as delusional thinking. I interpreted it differently.
What did you interpret it as?
That again is similar to maintaining a skull in a memento type fashion.
Have you ever,
the eating of body parts was in part initiated by curiosity, and then also in part that I would say, not experimental, but just an experiential way that perhaps that's the ultimate in having somebody become part of you in a symbolic way, in a very temporary way. So it's kind of a symbolic thing rather than being, he does not really believe that he eats some muscle and now the soul or that person is now embodied in him. Okay.
He never told you that he was eating them so that their soul would be embodied.
No, that was my word, but that the person was now with him and within him, lived within him, his spirit was in him. It was just a symbolic gesture.
Didn't he tell you that that's one of the reasons he was eating the body parts, so that the people would continue to be with him by virtue of the fact that he ate part of their bodies?
The experience, not that he was going to, as he walked around, he was harboring these people, no.
How about how many people have you ever dealt with in your practice that ever ate body parts of somebody they killed?
It's happened, we're certainly talking, less than 5, perhaps a couple. Yeah, I'd have to think about cannibalism.
Were any of those people who engaged in those forms of cannibalism found by you that they were delusional in their desire to engage in this cannibalism?
Do not know. All I can tell you is this type of phenomenon, you certainly, because of its bizarreness, certainly part of your differential diagnostic concern is whether or not the person is, let's say, schizophrenic and doing this for, and that this is a manifestation of primarily a schizophrenic or psychotic illness.
When Jeffrey Dahmer told you that he was bringing people back to his apartment, that he wanted to create zombies, that he drilled these poor people with an idea of somehow or another destroying their intelligence lobes so that they would be there for him, did you consider that to be delusional thinking?
No, not at all. I think that was a realistic attempt on his part to somehow disable a living person but not kill them. He was looking for an intermediate process here to avoid the work, and must have been drudgery, of the disposal.
Yeah.
You can knock somebody on the head and put them in an indefinite coma. A brain damaged person in a coma would have been just what he was looking for. That would have satisfied his process very well. Where he got the idea to drill from and inject and somehow damage the brain, I do not know. While he was telling me this, the neurosurgical corollary or parallel of a lobotomy, which used to be an old-fashioned psychiatric and medical treatment for advanced schizophrenic conditions before medications, that parallel never crossed my mind until much later. So in a way, it was just, so I don't know where he got that notion that maybe this is one way I can lay this person up.
Did you ask him where you got the notion?
I would assume I did. I mean, that's a natural follow-up question. I don't know if it's in my notes, but...
Certainly not in any of the notes you've read here.
If it's not in there, then I either did not write it down and or I did not ask him, but it's certainly a follow-up question.
Have you ever had cases where people drilled people's heads to destroy, well, any homemade lobotomies where the object of these people's conduct was to cause the unfortunate victim of those attempts to become zombie-ized, as Mr. Dahmer explained to you, for any purpose whatsoever? Did you ever have any cases like that?
I'm sure this is a first time internationally.
First time internationally?
Sure.
Now, you know...
But of course, I don't know every crime internationally, but
sure.
Mr. Dahmer is setting some precedents here.
Sure. The fact of the matter is, you know, as a doctor of medicine, that what he was attempting to do could not have worked, correct?
Well, again, I can give you a unofficial neurosurgical opinion on that. Depends on what part of the brain he is drilling into as to what type of damage you're going to get. It's similar to a stroke, which blood vessel is ruptures and what part of the brain is affected by the stroke, and that determines what type of damage you will get. It's possible that I would assume somebody could have been impaired and disabled had he hit a blood vessel and caused a mechanical stroke and the person could bleed to death. Then there's always a risk of infection and what have you, but I think it's possible that a person could be somehow damaged in a certain part of the brain and survive, and then the person is subsequently brain damaged.
And you don't...
So it's I would say it's theoretically possible that that could have worked.
Okay,
now, a neurosurgeon might say, Fosdal, it's a good thing you're in neurosurgery and you belong in psychiatry. So,
let me ask you this then. Let's assume that as you're talking to Jeffrey Dahmer, learning these things that are so unique, you've never heard anything like them before or since, as you have already told us. Did you say to him something like, well, Jeffrey, let's say that you succeeded. How long were you going to keep them? Was he going to raise them from the time of whatever their age was until when? Did you ask him any questions about how could you possibly think that you could create a zombie and did you go into that inquiry?
Yes, I did.
Okay, tell us about that. What his plans were.
Yeah, well, this came up a few times, and again, referring to my notes on page 26, again, the crux of a psychiatric forensic evaluation is to understand behavior, and of course, motive is very important. And on page 26, I'm quoting him as saying, I was trying to think of a way to not have to kill them, which was my understanding. On page 27, he called it an experiment. It never worked out. On the same page, he said he wanted the individuals to be, quote, open to my suggestion. I wanted an indefinite effect. The purpose was that they would be alive, the bodies would be preserved, but their personality would be made, quote, zombie, and that's clearly his word, not mine. So I wouldn't have to go out looking for partners. So one of the logistical work involved here is finding, besides disposal, is finding people. The advantage of having a lover is you don't have to look very far. But in his situation, tremendous time and energy and money to find a partner. On page 45, he said, quote, I wanted someone to stay around that was alive, which makes sense, unquote. He used an electric drill. Quote, I didn't want to have to keep killing, implying that the killing wasn't a good, that program was not working out. That had drawbacks. And just end up with a skull. He didn't have much to show for it after a few days. On page 48, quote, he said, I didn't want to keep on doing it, killing him. That's why I tried the drill technique. So it was an attempt to, this is entering a new phase in this case. On page 52, he said no, because that was the only mechanism, and he's referring to drilling, that I could get complete control at the time. It was only later on that I tried to change that to render them in a zombie-like state, to keep them alive, so they would be with me for a much longer period of time, alive, interactive, but on my terms.
Okay, now is it your belief that if he had succeeded in creating a zombie, that he would not have killed again?
That would have been a definite way out of his predicament.
I'm asking you what your belief is.
Oh, absolutely, absolutely.
You say if he could have created a zombie, he would have kept the zombie with him and never killed again.
Oh, I think unless you wanted two zombies, absolutely. That was a solution to his dilemma.
What was the first victim that he attempted the zombie on? What number, do you know?
Oh, you know, he told me it's in here.
It was after a number of victims.
Pardon me? Oh, yeah, it was later. I know he did it on Doc Stater. If somebody knows, we could speed this up.
Well, it was some time into his killing.
Oh, yes, this was much later because he needed the prior experience of the disposal and the drawbacks and what have you to begin thinking of alternatives.
Knowing that that's what he was telling you, that that's what his ultimate goal was, and knowing that it was not possible, you set aside the fact that what he was really telling you was delusional thinking, correct?
Well, like I said earlier, I think, again, ask a neurosurgeon, I think there is a possibility that he could have damaged a person, and he could have been successful in this approach. A neurosurgeon might say I'm all wet, but I think, like I've already explained this response, had it worked out, yes, indeed, this would have been a solution to his dilemma.
Did you ask him, let's assume that you were able to do that, Mr. Dahmer, how would he have been able, did you ask him how he would have been able to go about his business with somebody in his apartment when he was at work? How do you feed him? How do you clothe them? If you go away on a trip, how are you going to manage that? Did you get into that discussion with him to find out what his thought processes were, how he was going to create this zombie or not?
Well, we know how he was going to create it. How he's going to care for it is what you're asking. I did not get into much later details, but he did, in fact, on one case, he went off to work twice with this person still in the zombie state. So it's just like leaving a child or your cat at home alone without a body sitter or a babysitter, and came back the second time and was disappointed that the person had died. His hope was to keep the person, that the person would be alive. One time he came back and he was pleased and happy to see the person alive, but disappointed that the person was in a coma. Spent much of a Tuesday, I believe, trying to get the person more alert. So the person was too comatose, but
so the fact
later on feeding and bathroom care and that stuff, no, I did not pursue this thing endlessly.
All right.
The important thing to me, it told me that, and Mr. Dahmer confirmed this on a few occasions, what this meant to me is, at least as far as his first choice, as his real sexual interest was not in a corpse, let's say, but in fact that he was more interested in homosexual behavior with a live body rather than a corpse, and that takes it out of the pure or exclusive necrophilic category. At least that's one thing that suggests that this guy's not a pure necrophile.
Sure. You, as a matter of fact, when you met with him on January the 9th, you said to him, and if you want, I don't even know what page it is, but before you got into this business about the altar, you said to him, I think we kind of ruled out a pure necrophilic drive. And these are your words. I need to have the guy dead so I can do my sex thing. I want to do things homosexually with this person. And also I want to control this guy. So the issue is when we are talking about trying to control someone and not kill them, we are talking about putting your desires for homosexual behavior and also your desires for passivity. That's what you said to Jeffrey Dahmer. And he says, if it was a pure necrophilic drive, I wouldn't have ever started using the drilling technique to render them in a permanent zombie-like state. That's what his answer was.
True.
So what he says to you, that if it was a pure necrophilic drive, which are exactly the same words that you said to him, I think we kind of ruled out a pure necrophilic drive, correct? He used exactly your words.
Appears that way.
Yeah. And then you said, we haven't talked much about the altar. You brought it up, but I didn't ask you much. Was it crucial? And he said that was a center I was constructing in a bedroom with skulls on the table of the victims, 2 complete skeletons standing on each side, a large lamp with blue globe lights to give the room a dark blue mysterious effect, and with 2 incense burners on the end of the table. That was where I was planning on. And you said, did you get that far? He said, no, nothing got set up. It was to get in contact with the spiritual forces to gain power, to perform rituals to contact, I guess, demons or Satan. And then you said, do you believe in that stuff? And he says, yeah, and the purpose of it was to draw power to me in all aspects of my life, financial, social, sexual. If 6 more months had gone by, it would have been completely set up. I already had the table and planned on getting the lamp. All I needed was the lamp and the chair. Isn't that what he said to you?
Yes.
And you have discounted that as being delusional thinking.
That's true. Unusual, but not delusional.
Okay. You told us that people have before kept things as mementos for things they've done sexually. If I'm wrong, correct me. Have you ever in the course of your practice as a psychiatrist had anyone who explained that their homicides, amongst other things, were going to be producing an altar or a shrine or whatever you want to call it in order for them to put something together so that they could draw power from it? Did you ever have anybody like that before?
That rings a bell, yes. That rings a bell, yes.
How many times?
Oh, I can't. We're talking few. The issue here is there are crimes that involved some occult belief systems, satanic kind of stuff, and some of these people get into alterish kind of symbolic kind of things with skulls and all kinds of stuff going on, and candles and incense, and they're assuming all kinds of things going on.
Are they paraphilics only?
There's certainly, not uncommonly, some pretty unusual sexual behavior going on too.
But the people you're talking about, were they paraphilics or were they people who are suffering from psychosis? The ones that you just...
I think with the altar kind of, these were just people that were into this kind of way of thinking, occult beliefs, satanic kind of stuff, and not psychotic and not even paraphilic. It was just an unusual group, subgroup in our society.
Okay, but they weren't even paraphilic either.
No.
Oh. Am I correct in what I just said?
That's what I'm saying. They were just into, Rosemary Baby type stuff, the movie there.
Were they committing homicides?
The witches in Rosemary's Baby?
No, the people that you're talking about that weren't psychotic, weren't paraphilic, but were making
Well, certainly various forms of illegal sexual behavior was going on, from child molestation. I'd have to think if there was any actual human sacrifice involved, but that's all part of the same can of worms.
Doctor, it's clear that this is this the most unique case as you have described? I don't remember what word you used before, but internationally or something you said. How unique is it?
Oh, I would assume Mr. Dahmer is a precedent.
Okay.
There certainly been multiple, numbers of homicides, but I think what he was up to and the manner that he was doing things, I can't imagine that anybody has done anything similar to this. People have been killed for a variety of reasons, but I would assume this is a first.
A first.
Internationally, sure.
Does it matter then, well, first of all, you know that Dr. Berlin, Dr. Becker, and Dr. Wallstrom, but certainly Becker and Berlin, are on this subcommittee for the study of paraphilic behaviors. You're aware of that?
I'm aware they're on the committee, and I'm also aware that they are work primarily in the assessment and treatment of sexual disorders, which is a most commendable area of psychiatry to try to do something for, over the years, not a popular area of psychiatry to work in.
Yes. When you say it's not popular, you mean
Well, child molesters and impulsive people with, you name it, people on probation and people in trouble with the law who, this type of thing. These aren't the kind of people that walk into your office and call for an appointment and say, I've been molesting my stepdaughter or something. These people, you meet them because they get in trouble.
Sure. Obviously, you have a great deal of respect for people who do that.
Oh, it's very noble. I mean, it's more noble than my being in court. I'm not helping any person by being a forensic psychiatrist. Those people are trying to help unfortunate people, yes.
And as a result of that, you would, if you were a practicing psychiatrist and somebody with a severe paralytic disorder came to you, you might very well consider sending that person to somebody that has spent their lives working with people with paraphilic disorders, correct?
Oh, absolutely.
Sure.
I can think a few institutions in this state that would, we need this type of expertise, by all means.
See, we're going to move fast now because I think
Good.
I pretty much understand where we're at. You have told us that you saw no delusions in spite of the fact of the things that I've mentioned, and I don't want to harp on them in order to make a point. We're all bright enough to understand what I suggested was things that caused me some concern, and you've explained them, and I'll accept your answers. Now, what I want to know is this. Does the fact of the homicides, now this, maybe I'm going to get in trouble when I ask, I'm going to try it though. Does the fact of the homicides, if there weren't any homicides, and he did all of these other things, he would still be suffering from a paraphilic disorder, correct? Rendering people...
Yes, he's sexually disordered.
Okay.
Whether or not, even before he went the step of killing people.
Now, let's take him up to the moment of the homicide, and he doesn't kill. He sexually assaults, clearly having sex with somebody who's in an unconscious state, drilling somebody and trying to make them zombies. These are all crimes.
And slipping drugs.
And that's what I'm saying,
Right.
yeah. And slipping drugs.
This
and
could be a case of endangering somebody's safety by
or attempt murder.
whatever you want, and certainly disorderly conduct,
Sure.
at least.
Yeah. But it would have been very, very serious misbehavior.
Right. We don't have to have deaths to support a sexual disorder here.
Sure. And those crimes were the issue, whether or not he could conform his conduct to the requirements of the law. Your answer would be that he could at all times conform his conduct to requirements of law in spite of his mental disease because he did not lack the substantial capacity not to conform, correct?
Right. Can may I expand for 1 second?
You can do anything
Thank
you
you.
want.
Basically, the motive for drugging the person was essentially the same as the motive for killing the person, but just a milder and less fatal, less lethal program. And that's certainly just to maintain the relationship with a living person. So were he charged with endangering safety or something like that, he did not have to. He could have controlled which people he was going to attempt to drug and things like that.
Now, with that in mind then, the homicides, albeit the worst part of everything that happened was the worst part. The homicides obviously were the fait accompli. Your answer is that Jeffrey Dahmer, in spite of his mental disease, did not lack substantial capacity to conform his conduct to requirements of law, correct?
True.
Okay, now, the fact that he planned where to go, planned the kind of people he wanted, how he conned them into coming back, how he took them by cab and got out 3 blocks from his house, how he put powder in their drink having first mixed it, are all those kinds of things that he was doing such that as an experienced psychiatrist, you are making a conclusion that he could not have lacked substantial capacity because he was able to do all of these things towards the furtherance of his paralytic goals?
Yes, I am, and this relates to the, expanding again, how do you assess and evaluate wrongfulness and conformity for legal purposes?
Okay.
And I would state that my process is the same process that a jury uses or somebody else, and that is that wrongfulness and conformity is an inference based on what people say and do. So if in fact I wear a mask when I rob my store, I'm trying to conceal my identity, I must be aware of the wrongfulness. So that I'm concluding from that, I'm inferring from the person's behavior and how he or she committed the crime. Similarly with conformity, it's an inference that an examiner makes, it's an inference that a jury makes, that type of thing. So it's inferential thinking.
And obviously reasonable minds could differ on how they infer those.
Well, that's what's going on in this case.
That's
We're
right.
all at the same thing, and some examiners are inferring lack of capacity to conform. I am inferring capacity to conform.
Okay, fair enough. Now, let's talk about the alcoholic. An alcoholic has a sickness, does he not? It's true.
Pardon me?
An alcoholic, isn't alcoholism a sickness?
It's a disorder, yes.
Yes, it's a disorder. Now, if the alcoholic, while he is in the sickness or the disorder of his alcoholism, hides bottles in places so he can go, and I want to make it clear, I'm not trying to put these in anywhere near the same category. I just want to get into your mind a little bit if I can. If the alcoholic is hiding his alcohol and is doing it at times when he can't be detected, drinking something that's keeping him from being having the smell, such as some alcohol they say doesn't have an odor like vodka, that he is only doing it when his family is out of the house. The fact that he makes those choices is not dispositive that he isn't an alcoholic, is it?
No, he is an alcoholic, and his alcoholism and his need for alcohol explains the motive behind much of his behavior.
And if he is an alcoholic who is a binge drinker and he only drinks from Saturday at noon until Sunday night at 6, the fact that he's able to not drink except during those times doesn't mean that he isn't an alcoholic, correct?
No, he still has alcoholism.
Let's talk about Jeffrey Dahmer's mental state as he's going through this killing spree. Is there such a concept of the growth of one's mental disorder? Do mental disorders get greater as time goes on, like a cancer might? Well, I think a cancer does grow until it's stopped. Do we have mental disorders that increase in their strength as one is going along the pattern of acting out on their mental disorders? Is that a fair concept?
The degree of impairment can increase let's say the schizophrenic illness starts out, a gradual decompensation, a gradual worsening of the condition, and the longer the person is off medication, what have you, yes, some people become very, very floridly psychotic and over a period of time. So, and depression can become more and more depressed. That's
Let's talk about
clinical course.
I'm sorry. Let's talk about Jeffrey Dahmer's paraphilic disorder, whatever it is classified, and I understand the only classification you're giving it, it's a paraphilic disorder. Did that worsen in its intensity? That is the illness. Worsen in its intensity as he was going along his life's cycle, as he started going after the Hicks murder, through the Toomey murder, and continuing thereafter. Was that disorder intensifying in its strength, if there is a, that's kind of a bad thing to call it because it's a negative, but you know what I'm talking about.
For sure, his behavior became more reckless, and there was a worsening of his behavior, progression in the, let's say, number of deaths, and toward the end, a little more frequent, in part related to, let's say, his unemployment and other, but at least, yes, there was a progression here. Whether or not that's all due to his an increase in sexual need, or just more of a reflection of the other contributing factors, such as his, getting away with it, not feeling deterred, being successful at it, getting bolder, more increased intoxication, these types of things. It's a mixed picture, but certainly there was it didn't stay at a once-a-year phenomenon. It certainly was progressing.
Besides his behavior, there was a worsening of his mental disease as he prolonged, that was caused, amongst other things, by the fact that he was doing more, was making that mental disease worse, correct?
The fact that he was, I'm sorry.
Forgive me, could I have that question again? Mr. Boyles.
Oh, I'm sorry.
Oh, you were asking me? Oh, yeah.
Question. Besides his behavior, things at work, things are worsening of a mental disease that was prolonged, caused, amongst other things, that he was doing more, was making that mental disease worse, correct?
Let me rephrase the question.
Thank you.
Do persons' paralytic disorders get worse, the disorder themselves, get worse without treatment?
That can happen.
If I have a paralytic disorder, paraphilic disorder, and I allow it to continue unabated, in spite of the fact I'm not acting out, is it your belief as a psychiatrist that unless I start getting some help that I'm going to become worse and worse as it is related to the paraphilic disorder?
Objection. Could we approach the bench on this?
Is this going to be a long argument? Or?
Let me rephrase it. Let me rephrase it.
Mr. Boyle wants to rephrase his question.
I think any rephrasing is going to raise the same issue.
Well, let me try
Not the form I'm objecting to, it's the subject.
Just so I think you understand, but so everybody else understands, the reason I raised the question how long the argument's going to take is that I think that if it's going to take a while, it's more appropriate that we excuse the jury so they can go to the comfort of the jury rooms, so much as it happens to be, rather than have to sit out here in the courtroom while we're proceeding with an argument back in chambers. It also facilitates the considerable people from the public who are here to be able to witness the argument rather than have to get a report of it secondhand.
If the court...
The issue speaks to at 971.16 sub 4.
He's ahead of me, but I don't know what he's saying. 971?
.16 sub 4.
Oh,
Particularly the portion that starts at page 4762.
I know what he's talking about. Let me rephrase the question. I agree with you 100%. If I'm going into that, I can't, and I understand it. I'm not going to go into that. Let me try it this way. When one has a disorder of a paraphilic nature, does that disorder remain constant at all times? Can it dissipate and can it grow, or can it grow? You understand my question?
You can go in one of three directions.
Okay. So when it goes in a direction that is the wrong direction, then a psychiatrist would obviously say the condition is worsening.
His behavior worsened.
Well, but let's assume there's no behavior involved. Just the thing itself. That's really what I'm asking. He doesn't act on it. He just has it, and it can go one of three ways. I can have a thought and get rid of it. I can have a thought and leave it at that thought and just continue with that thought and that thought alone. Or I can allow the thought to multiply and multiply, correct?
I'm trying to picture what you're asking, and the way I would respond is that in Mr. Dahmer's situation.
No, I'm really asking both. I'm asking just a person who's got a paraphilic disorder.
Well, okay, the child molester. He's molesting children because first of all, his first choice is adult women. He fantasizes adult women. He buys adult women magazine. That's where he's at. But due to his feelings of personal and social inadequacy, his personality makeup, he's more comfortable. His ego is about the same size as the child he's molesting, and that's why he's relating at that level. That individual, with time can be mature, become more comfortable, can have a successful adult experience somehow and grow and not resort to children anymore. That's a good way to go. Or he could, you're saying if there's no behavior and that's just what he'd like to do, but he knows better and he never does it, that he can stew and be distressed for a lifetime. Or eventually, he gets over it. He doesn't think about it. A lot of I've known people that, former patient of mine, when he was younger, it was touch and go for a long time for him not to do what he wanted to do. And he got in trouble a few times. As he's gotten older, it's not an issue anymore.
Okay, that's what I want to know. Thank you. I want to ask you this. Did you talk to Tracy Edwards?
No.
Did you know before you saw Jeffrey Dahmer the last time that there was a fella by the name of Tracy Edwards who had been with Jeffrey Dahmer for a period of about 4 to 6 hours and appeared for all practical purposes as his next victim? Did you know that person existed?
Yes, that's in the reports.
Did you in any of the reports read anything where Tracy Edwards was asked, and I'm talking about the reports, as to whether Jeffrey Dahmer was doing anything bizarre or not while the two of them were together? Did you read anything in the reports where that question was asked and discussed with Tracy Edwards?
I'm sorry, who am I asking?
I'm asking you if you found in the reports anything that gave you the answers to how Tracy Edwards said Jeffrey Dahmer was acting within that 4-hour period.
Edwards described what transpired. I don't recall him describing that Jeffrey Dahmer was bizarre or unusual.
Did you come to learn that Tracy Edwards did answer the fact that at some time during the time they were together, that Jeffrey Dahmer was, and I believe his testimony is in the record, and I don't want to misstate it, but when he went out and talked to the police, he used certain words about how he described Jeffrey Dahmer. He also told this jury about how Jeffrey Dahmer was chanting and rocking back and forth. Did you, before you came into court today, did you become aware of those facts?
Yeah, I was aware that has been stated.
When did you become first aware that Tracy Edwards made that statement?
Oh, I think that's pretty recent.
Okay, now, is there a reason that a forensic psychiatrist, as qualified as you are, chose not to talk to a live witness, the potential 18th victim, and ask him how the person you were making a decision about was acting in the last few hours before the defendant was arrested?
Sure, I could be criticized for that. There are several people that I could have investigated endlessly. It becomes a matter of time, money, and you name it. But yes, there are other people. In this case, the way this has most commonly happened is that police reports have statements from people involved. And as an examiner, I certainly do not re-interview and take statements from a variety of people. Sometimes I do interview certain people. And also I recall, and I must have learned this from Mr. Dahmer, or maybe I learned in papers, that did not Mr. Edwards leave state for shortly after this happening and go south or in Texas? I do remember the feeling that he was not available, or this person has since taken off. Then later I learned that he was maybe back in the area. So I guess he had some publicity himself. He had his own case going, and I seem to recall he was kind of really not a high likely type participant to interview. And I would accept whatever data is derived from police interrogation. That's the value of police reports. Other people are gathering information from a variety of sources, and it's just not my role to the cost and a variety of things. Time would be almost prohibitive to meet everybody involved, so you're quite selective in who you spend time with. Mr. Dahmer, in and by himself, required so much time.
Yeah. Your first meeting with him on 10/16 was background information primarily.
Right, I wanted to know who he was.
Sure. Your second meeting on 10/23 was pretty much background information, but you got into his early thought processes in his adolescence and young adulthood. Is that pretty clear?
I remember I needed some time frames and some organization, some overall organization to this case, where he was living, what's going on at different time frames, that type of a thing.
Your next meeting on October the 13th, the only homicides you talked about as specific homicides was 2 or 3, right?
Maybe specifically, but certainly throughout the interviews, certainly the second and third, there was certainly a general discussion of a general motive, that type of thing.
The fourth interview on December the 20th is where you went through each and every one of the homicides.
True.
Now, you have testified in the courts of the state of Wisconsin for the past how many years?
20.
And is it safe to say that if one were to say, just so you understand, I know you and I respect you and I'm not trying to embarrass you, I'm just asking some questions.
Thank you.
If it's safe to say that Dr. Fosdal's primary field of psychiatry is forensic, which means that he spends a great deal of time in the criminal justice system determining whether people are mentally ill and competent to stand trial and investigating matters of that type.
For several years, it's flip-flopped. 20 years ago, forensic practice was it was forensic, inpatient psychiatry, outpatient psychiatry. By the late 70s, I could not have 3 patients in Madison General Hospital and be in a Milwaukee County courtroom and have the judge tell me at 5 o'clock we're adjourned until 9 tomorrow morning, and I tell the judge I'll be through in 2 minutes, Can we continue 9 o'clock tomorrow morning? And then I have to get coverage for my inpatients. Too much of that. I stopped doing inpatient work. He was forensic, and the forensic stuff grows. It's like half and half for many years. And finally, for the last couple of years, it's been pure forensic psychiatry, civil and criminal.
You're no different than lawyers who choose to go into a certain part of law, so I'm not criticizing
Well, that's
that.
the way things evolve, yes.
Of course. Now, in the last year, how many cases have you testified to in a courtroom on the issue of mental responsibility? Just generally.
In 1991, what are the 92 this year?
Any calendar year, 19. What are you in court, 25 times a year, 35?
I might testify in small hearings, telephone hearings to major jury trials, perhaps 30 times a year.
Okay, now how many mental illness cases, such as you're here on, have you testified to in the last 5 years? Just give me a ballpark figure if you can.
How many times in 5 years have I testified on mental responsibility?
Yeah.
I can estimate, or I actually know. Several times a year I testify on mental non-responsibility.
You indicated there's three.
I do. I perform 60 to 75 exams a year on this question. Not all of them lead to testimony. Commonly the issue gets settled, commonly the plea is withdrawn, commonly there's agreement amongst all examiners, and there's just token testimony and the person's processed. Sometimes there's a big contest involved.
Please get drawn a lot.
Get what?
Withdrawn quite often.
Well, you probably know more about it than I do, but I certainly commonly do not appear later in court on a non-responsibility case.
Now, there are really four ways of you being appointed as a forensic psychiatrist in a criminal case. One, where the judge appoints you, correct?
That's true.
Two, where you're hired by the district attorney and you render an opinion. Obviously, you're a very fine professional. Your opinion would have to be turned over to the other side, but you're hired nonetheless by the state to do an analysis and to render the best opinion you feel is appropriate under the circumstances. That's another way you're hired.
True.
Another way that you're hired is by the public defender's office.
True.
And sometimes being hired by the public defender's office, they ask the court to appoint you.
True.
And that's a budget thing, isn't it? So it comes out of the court's budget rather than the public defender's budget.
That's what I commonly recommend to defense attorneys in discussing payment, and certainly with the public defender's office. You're better off trying to run it through the court.
Has there been situations where the public defender makes such a motion before he knows what your opinion is, or does that not matter?
Yes, on occasion, defense attorneys call me. Will I see this person? Yes, we discuss things. My first choice would be to be court-appointed, have the county pay the bill. Even if I'm court-appointed, you still have full access to me. My findings are the same. You can meet with me just as much. No side owns an examiner type thing. I'd rather, if possible, sometime private defense work. It's fortunate if the attorney gets paid, let alone the client can't pay me.
That's right.
So let's try to run it, if possible, run it through the court. But sometimes it doesn't, and then we run it through the public defender's office.
Then there's another way you get into these cases, and that's where a private defense attorney would hire you, and he would pay, or he would see that you were paid from private funds, correct?
Yes, that happens.
Right. Then there's another thing that happens, and that is where the parties agree that these are very good doctors, this list, and they say, Judge, all of these doctors are agreeable to both sides, and then the judge appoints. So you really become an appointee of the court by reference or by suggestion of the parties, correct? That's another way.
I think that's the most common way.
Yeah. All right. Now, how many, I think you said 70, I thought you said 70-30 was the balance as to how you are involved in these cases, and I really missed how that came about. Did I quote you right? I heard you say something about 70-30. 70% of the time you're something and 30%?
No.
Oh, tell me about that.
I'm saying 2/3 criminal, 1/3 civil. The vast majority of appointments are court appointments. As far as you're probably talking the times my findings support the plea or do not support the plea, and over the years it runs like 25% of the time, 20 or 25 or even up to 30% of the time. 3 out of 10, 2 out of 10 my findings support non-responsibility. The other times they do not support the plea.
In the last 5 years, how many times have you been hired by a private defense attorney and paid by that private defense attorney to come into court and in fact render your expert opinion?
In a criminal case?
Yes, sir.
Infrequently. Infrequently. Civil work is much more private. Criminal, private defense, almost everything in the state, much more commonly is public defender.
You say infrequently, how many times?
Oh, we're talking,
Once,
5
twice,
years?
3, 5, 10?
Oh, who knows, 5, 10 times. That's not the usual routine.
Well, you've given us, and you were kind enough to give us the amount of times that you're appointed and which way you go. 2 or 3 out of 10, you don't support the plea, or you do support the plea. So that's been very, very fair of you to answer.
There's also another category, that's a stipulated category. I'm not counting those times.
Stipulated category is where there is an agreement by all of the parties as to the conclusion of the doctors.
True. Well, I use that term probably incorrectly, but I'm saying sometimes I take the liberty to say, even though strictly speaking, the person, in my opinion, does not meet the standard, all things considered, consideration could be given to managing this person under such a commitment.
You have entered into an agreement with the state of Wisconsin for your psychiatric services relative to the costs of your involvement in this case from the time that you were first retained the day after Mr. Dahmer was arrested up to the first time you saw him, October the 16th, and the 5 times that you saw him, and preparing yourself and reading the records. What is the total amount of monies that you have either been paid or expect to be paid for your work on this case?
Up to today, I have billed Milwaukee County, including my first visit on, the day after the apprehension, and I have billed for 84 hours up until my last bill. And since that time, of course, we have this whole week, other preparation, a couple long days of preparation, 2 days of court appearances. So the 84 hours, I've been contracted at $125 an hour, so times 84 is $10,500 I've billed out so far. And I certainly have, well, let's say even another 35 hours is $4,375, and I suspect it'll be more than the 35. So we're approaching at least another $5,000 in billable time, and this reflects the bulk of my time. I certainly do not stopwatch my time, but I try to, this accounts for bulk of it.
Okay, now, the disadvantage that you have as a state psychiatrist, as opposed to a defense psychiatrist, is that you can't talk to the defendant until first allowed to do so, correct? By that I mean, you can't just, like a defense doctor, get information about the defendant until the defendant gives it to you, correct? Unless privilege is waived.
Yeah, you're talking about the state's examiner getting in early?
Well, I guess let me rephrase it. Doctor, if I had employed you and before you walked in on October the 16th to talk to Mr. Dahmer, I might have been able to save you a lot of hours of time because I could have told you and given you what he has been telling us and given you some writing samples if there were. I could have given you tape recordings if there were. I could provide you with a lot more information before you walked in. As a as a state psychiatrist, you're at a disadvantage because you can't get that from the defendant, correct?
I don't know. I can't imagine much more information being available.
But when you walked in on October the 16th, you had no idea what Jeffrey Dahmer had said to anybody other than the police, true?
Yeah, I did not know what he said to defense examiners.
Or to anyone else other than
True.
what he said to the police?
True.
Okay. If we were to break now for lunch, and I were to be able to just look through my notes and talk to my associates, I'll bet you I'll save us 45 minutes of time, and I think it might be a good thing to do, Judge.
Sounds like you're requesting that we recess at this
Yes,
point,
sir.
Mr. Boyle. Okay. We'll break at this time. What time you want to come back? 1:15?
Fine with us.
Okay, let's make it 1:15. Court's in recess.
All right, please.
Go ahead, Mr. McCann.
If it please the court, shortly before the opening of court this afternoon, I approached your chambers with Mr. Boyle and requested an opportunity to briefly address an in limine issue so that I might appropriately instruct a witness we intend calling within the next several days. That witness is Dr. Park Elliott Dietz. In my last conversation with him, we discussed the potential of using portions of that videotape during his direct testimony. From a strategic viewpoint, I agreed that I would first request up to an hour. If the court seemed concerned about that, I would request half an hour in total for use interspersing his testimony using that videotape to highlight certain points. I find no case in Wisconsin that directly addresses that issue. We've done research and found some cases that address the converse side of it. In one case, which is cited, United States versus Byers, which is cited in our recent Lind case. The Lind case appears at 161 Wisconsin, 2nd at 324, and in Lind they cite Byers, although for a different purpose. In United States versus Byers was the District of Columbia, and a defendant in that case attempted to suppress psychiatric testimony put on by the state because the state had not videotaped that interview, and they pursued an argument to the effect that the state had failed to preserve evidence that would be exculpatory, and that therefore the psychiatrist should not be permitted to testify because they had not preserved. Now, that's the somewhat converse of what we have here, although I wouldn't be surprised to see Mr. Boyle make a motion maybe that Dr. Fosdal's testimony wasn't preserved. At any rate, I can't find a case where the state attempted to move it into direct evidence. I would ask the court to take note, however, in State versus Lind, where our court pointed out that on page 365 at the bottom, we note as a general matter that the Constitution does not apply to prohibit the admission of testimony of a state psychiatric expert in circumstances where the defendant already has interposed an insanity defense and has presented expert testimony in support thereof. At that point, they do cite United States versus Byers, general concept. Also in Lind, they address the Estelle issue and point out that this is a different situation than existed in Estelle. I do call the court's attention to the case of State versus Caput, 142 Wisconsin 2nd 370, where this phrase appears in the opinion. Rather, speaking of this type of proceeding, the responsibility proceeding, rather it is a special proceeding in the dispositional phase of a criminal proceeding, a proceeding that is not criminal in its attributes or purposes, and pointing out that the 5/6 verdict is sufficient. In another case, and I won't cite a lot of cases, in Thornton versus Corcoran, a federal case 407 Fed 2nd 695, 1969, the court actually ordered that the psychiatric interview be tape recorded. In terms of, and I see the court's mood, and I'm suggesting half an hour that he be permitted to intersperse pertinent selections from that videotape, taking up to half an hour, and I would call the court's attention to 90703, strike that, 90705 of the Code of Evidence, which reads as follows. This is the general code on expert testimony. The expert may testify in terms of opinion or inference and give his reasons therefor without prior disclosure of the underlying facts or data unless the judge requires otherwise. The expert may in any event be required to disclose the underlying facts or data on cross-examination. I just suggest that that's the closest I can find. I think the assumption is that if on direct the expert chooses to set out the facts on which he sets his opinion, that certainly that would be permitted. I think that that's implicit in 90705. I'm aware of as this issue arose yesterday on the audio tape, and the court relied on 971.16 sub 4. That reads, the particular section, I think, upon which the court ruled, reads as follows. The physician or other expert shall be permitted to make an explanation reasonably serving to clarify his or her diagnosis and opinion, and may be cross-examined as to any matter bearing on his or her competency or credibility or the validity of his or her diagnosis or opinion. I believe that this is reasonably in advance, is a reasonable explanation of the opinion to show selected portions of the videotape. And with that, I would request, just so that I can adequately give notice to our witness whether it will be permitted or not for preparation purposes, I would ask the court for an in limine ruling. I will point out there was, as the court knows, there was a hearing on this for the initial videotaping. Court ruled on that. The only thing I see is germane, any discussion between the doctor and the defendant, and this is from the tape. It's a question and answer. The defendant says this at the early stages of that taping. It's hard enough trying to open up to one person, but to have that in front of the whole courtroom, I don't know how candid that can be. Is there any way you can make sure so that it is not shown in court and just use it for your lectures or whatever you're going to use it for? This is the defendant speaking to Dr. Dietz. Dr. Dietz's response, I hadn't been planning to use it with lectures because the court has ordered that all originals and copies to be turned over. Then the defendant, oh, okay, but they will be watching, they will be watching that in court, question mark. Then Dr. Dietz, I don't know the answer to that, but I think that if either side pushes to make use of it to prove or challenge a point, that they probably are able to do that. I think if I were testifying and whoever is cross-examining me wanted to challenge something I said with use of the tape, they'd be free to do that. Then the defendant says, well, I'll do my best, I'll just try to forget that it's there. I guess I've never been videotaped before, so. And then that's as far as I can see, that's the essence of the discussion here. I would draw a slight distinction here between Pennsylvania versus Muniz in this case. Pennsylvania versus Muniz is 110, Supreme Court 2638. In that case, there was an attempt to present a videotape of a confession, and the court said no, it just for various reasons did not permit that. So I appreciate the court giving me the time to request this in limine ruling. It will be of great assistance to our witness so that he'll know whether to prepare anticipating this or not, and I would ask the court's ruling on that. Thank you very much.
Mr. Boyle, do you have a position?
Yeah, I'm obviously very much opposed to it. It's never happened in the history of the state of Wisconsin. There's never been a situation where in this type of a hearing such has taken place any more than calling the defendant adversely. If we want to charter some new waters, I guess we'll have to take the chance that we better be right on the chartering of those waters. I think it is somewhat I know everybody's motives are usually pretty good, but I am not suggesting that this being done to achieve an object they couldn't otherwise achieve, but it's just not fair to 5 months after the fact do something on a video supposedly for the help of making what? Notes. You don't make diagnoses on what a person's condition was at the time of the commission of the offense by how they're sitting in a room answering questions. And it's just not fair. And I guess I could be foolish enough to open up some doors by asking some dumb questions. This puts me in a very, very tentative position that I'm going to have to be extremely careful that I don't open up doors. I'm the one that makes the choice with the advice and consent of the defendant as to whether or not he's going to testify as to what he says happened. That this is an attempt to take that choice away from me by some rule of law that is not applicable in this state. In the civil end of it, there are videotaped depositions that are set forth in a procedure, and adverse examinations are clearly have to be respected. I was out of town when this whole videotaping business came up. I accepted Dr. Dietz's professionalism, that the reason that he was doing it so he didn't have to sit down and write out notes as he was going along, like the rest of the psychiatrists have been historically for the last 50 years. So I just am very much opposed to it. And if it's going to require any argument, any further argument, but I can absolutely assure you that if one picture of Mr. Dahmer gets in answering one question, we run the risk of the entire thing having to be shown, number one. And number two, the first day was not videotaped. So I just think that the court should handle this in exactly...
Well, I think it wasn't. The videotape was of some books, I believe.
Well, whatever. But we know it wasn't of the...
But I say that for a reason, because there was I believe a recording was made of the sound. That is the questions and the responses to the questions.
I think Mr. McCann's request is, to his great credit, that we're getting it up now, but I'm opposed to it, and if I'm going to have to start researching it, then I'd like some time. I don't know where it's ever been done before. It's just not the way, I don't think, the spirit of these kind of cases ever contemplated. Allowing a doctor to videotape people who are using this defense and then to go into a courtroom and be able to open up the door to showing the defendant when the purpose of the examination is to give the doctors a chance to render a decision so that one side doesn't gain an advantage over the other side.
Mr. McCann.
Yeah, just very briefly, the nature of this is not, of course, a criminal case. The nature is in the proceeding where we try to communicate to the jury everything we can about the defendant. Hence the very broad induction and use of evidence from the whole spectrum of the facts of the case. And Mr. Boyle has strategically, the defendant has sat here not between key counsel, but between two assisting counsel. He doesn't write anything. He sits there. He doesn't read anything. This is obviously, Mr. Boyle is an excellent lawyer, to influence the jury. He's communicating the defendant by sitting here. We all know he is not adult. He has above or average or above intellect. That's been consistent testimony. And yet, and I'm not saying it's a gross affectation of being adult, but by sitting there, it's clear that there's some communication. This man is not adult. He is articulate. He is intelligent. And this would communicate that to the jury, precisely the individual that they're dealing with. And it's in the attempt to the universality of pursuing the truth. I haven't researched this issue myself, but the court knows, I think I can tell the court, that he told Dr. Dietz, as he communicated to Dr. Fosdal, that his preference was live persons, totally compliant live persons. If I understand the testimony of Dr. Becker, not of Dr. Berlin per se, but Dr. Becker claimed that on Sunday night, a week ago yesterday, that he told her in a 1 hour and 10-minute interview that it was attended by Berlin, although Berlin did not testify to this, that his preference was that the person, his utmost preference was that to masturbate or to insert himself into an incised front anterior portion of an individual, opened and, as I understood it, to in effect have sexual congress with the viscera, if I understood her statement. That is, we have documented taped evidence that that was not his statement to Dr. Dietz. That although he talked about it, he did not talk about inserting it, as I recollect, was flatly put that question with respect to Hicks. So from an impeachment factor, now I'm introducing a different issue than I did in my opening motion, and I understand that. I would ask the court, I understand you're saying on the positive end of it, but I'm going to ask that if you'll take under reservation at least that issue where there's flat impeachment. I don't think we need that answer right now, because I sense you're going to rule against it, and I understand it's new law, and one does not wish to jeopardize a 3-week trial by cutting new law, and I can understand the courts. And I've reflected at length before I did that. We've debated interiorly within our office whether we could call the defendant, attempt to make law in that regard, and decided not to do it, although I rather firmly believe the court would not permit it anyways. But I think this is important in this case because I think it would throw more evidence on it. So with that, I will, having presented the argument, I appreciate your taking the time so that we can communicate to Dr. Dietz what will or will not be permitted.
Mr. Boyle, I really don't think I require further argument. Frankly, I'm persuaded to rule in your favor right now. If you want to try to talk me out of it, I suppose...
I don't need about any argument. I want to put on the record that regardless of what Mr. McCann's opinion is, Mr. Dahmer has not been given any instructions. He is not writing because he's been instructed not to. As a matter of fact, the opposite is true. He is sitting between my two co-counsel because I have to be towards the end so I don't have to be disturbing everybody every time I get up. And frankly, I just think that whatever this word dolt means, I think that when counsel starts guessing as to what my motives are, he'd do me a great service if he'd asked me first, because I think I could let him know that he's wrong. And I'm not too sensitive, but he's just wrong. It's not being done to persuade the jury about anything. I've been doing this for too many years.
As I've already indicated, it is my intention to rule against the state's request. However, it's not because this is simply modern technology. If any judge in Wisconsin and perhaps the world has had experience with modern technology in the courtroom, it's this one. I point out to you that on one occasion we took testimony from London, England, which was presented in a courtroom here in Milwaukee. When this issue originally was raised in terms of whether or not it was permissible to utilize a videotape, the court's rationale was that the expert had the right to make notes of his examination. Those notes could be with paper and pencil. He could also use more advanced technology in taking those notes. He could record, audio record. I also felt that today video is a very common means of making recordings, and that video was appropriate if he chose to use it as a means of making notes. What's being asked for now is something a little further than that. And I think the court at this point has to draw a line. I know of no authority in Wisconsin that says that it's appropriate to use these video notes as a part of the expert's direct examination. Now, one of the things I look at is, because according to the law, we follow the civil rules here, and in terms of the civil use of video depositions, it is permissible for a deposition of a party opponent to be used as evidence. But that's a deposition taken under some very special circumstances. Most importantly, that the litigant is represented by counsel. That didn't exist here. For all of those reasons, it seems to me that it's inappropriate to use it in terms of the direct examination. Now, things may happen in terms of the cross-examination, which might make it appropriate for all or parts of those video recordings to be brought into the case. That depends, of course, a little bit on how Mr. Boyle proceeds, but it would be the court's ruling that there's an absence of authority for using it as part of the direct examination. But I want to make it very clear, I'm limiting it to that. That if something happens during the course of the examination of this witness that makes it appropriate, the court's not restraining itself from altering that ruling. So I hope that provides the guidance that you're looking for at this point, Mr. McCann.
It does, thank you, Judge.
Okay.